Good afternoon, Mr. Hasselback.
Good afternoon, sir. How are you?
We're all fine.
Thank you.
A little tired, but fine. I'm gonna swear you in, and then please state your name and your title and the office you represent.
Yes, sir.
And then we'll continue with the question.
Okay.
Please raise your right hand. Do you swear or affirm under penalty of law that the testimony that you're about to give is the truth?
I do.
Thank you. Please state your name for the record and your title and your...
My name is George Lloyd Hasselback. I am currently employed by the CNMI Office of the Public Auditor. I have two primary roles there. My first is I am legal counsel to the Public Auditor's Office, and secondly I'm in charge of the OPA Investigations Unit, which consists of 3 investigators, 2 of which you've spoken to already today.
Thank you. Mr. Hasselback, we probably will not get into the report that we have already questioned your 2 investigators. I think we did ask pretty much all the questions at length. However, you are also the special prosecutor under this investigation.
That is correct, sir. I, pursuant to CNMI statute, I filed the criminal information and the amended criminal information in the case. I'm sorry, it's I'm not sure the case number, but it's a CNMI case, Commonwealth versus Edward Buckingham, that concerns criminal charges that were brought up that relate to the issues before this panel today.
Thank you. Because this matter is also in the courts, are you at liberty to answer questions relating to the incident?
Yes, sir. I'll be happy to answer whatever questions I'm able to. What I would suggest is if the members of the panel have questions, please ask them. I'll be very candid with what I can answer. There are some things that it wouldn't be prudent for me to answer at this point in time because investigation into these matters is still ongoing. But there are quite a few facts that are a matter of public record, and if there's any clarification on those facts I can give, or if you have any questions about the process that I can shed some light on for you, I'd be happy to answer those as well.
Yes. Just first, perhaps some clarification is in order. I understand that Mr. Buckingham's legal counsel, private legal counsel, is asserting that you are not an assistant attorney general?
Yes, sir. There has recently been filed a motion for reconsideration. It's got a longer title. I'm sorry, it's not in front of me right now, but it's a motion for reconsideration and other things. One of the issues raised in there by Mr. Buckingham's current counsel is that I am not an assistant attorney general. I'd submit to the panel that I brought this case pursuant to a specific CNMI statute. It's 1 CMC 7847B. I would encourage you to take a look at it if you haven't already. To paraphrase 1 CMC 7847B, if the Office of the Public Auditor, in the course and scope of its investigatory duties, comes to believe that it has information indicating that either the Governor or the Attorney General of the Commonwealth have committed criminal acts, the Office of the Public Auditor is authorized by that statute to file a criminal case in Superior Court. That statute goes on to explain that the Public Auditor has 2 options. The Public Auditor can either use legal counsel for the Office of the Public Auditor or secure the services of some independent counsel to be hired. And that person, whichever choice the Public Auditor makes, that person acts as an Assistant Attorney General. So, in other words, that statute says, under certain circumstances, OPA can file criminal charges. If those circumstances arise and OPA files those criminal charges, the attorney working for OPA acts in all manner as an Assistant Attorney General, meaning he or she would file that case with the Superior Court by filing an information and either seeking an arrest warrant or a penal summons, which is what happened in this instance.
if that is the case, why would the counsel for Mr. Buckingham assert that you do not have that authority?
Sir, I don't know. I'm sorry, that's a very unsatisfactory answer, but I don't know.
Thank you, Mr. Hasselback. The other point that the attorney for Mr. Buckingham has raised is whether the summons that was served to Mr. Buckingham was valid or proper or legal, and I think it has to do with that this is a local matter with the local courts, and you have federal agents serving the summons. Can you respond to that?
Well, sir, I think I don't want to get into specific responses to motions filed with Mr. Buckingham's attorney, but what I will do for you, I will explain the reason why this was served by a federal special agent. In this case, a special agent for the Federal Bureau of Investigations. I would encourage all the members of the panel to take a look at the penal summons. This is a document that bears the caption of the Superior Court of the Commonwealth of the Northern Mariana Islands. It bears the signature of Bernadita A. Sablon, the then and now Clerk of Courts. And it is not a document that originates from the Office of the Public Auditor. I think it would be helpful for everyone to understand that this is not a document by which the Public Auditor, or myself, or any member of our staff commands or requests anybody to do anything. This, I would submit to the panel that this document is a command from the Superior Court, in this case via the Clerk of Courts. And penal summonses in general tell people to be at a certain place at a certain time. Now, I filed this on Friday, August the 3rd, about 11:30 in the morning, and I had initially planned on waiting till the end of the workday to serve Mr. Buckingham, in the understanding that he would no longer be the Attorney General at the end of the workday. I found out about 3 o'clock that afternoon that Mr. Buckingham intended to remain in the capacity of the Attorney General even after he left Island. So I instructed Juan Santos and Juanette David Adelig, my two investigators that were assigned to this particular portion of the case, I asked them to please serve Mr. Buckingham with the penal summons and a copy of the information. They sought to do so, ran into some difficulties, and I won't burden the panel with a repeat of that again. I'm sure you've heard it before. If you have any specific questions, I'd be happy to answer them, but Juan and Juanette were the two best suited to answer those questions. At a certain point in the evening, Juan and Juanette, in collaboration with myself, they reached out to the Department of Public Safety and to the Commonwealth Ports Authority to get both of those agencies to help them serve this penal summons. A little bit later in the evening, I was contacted by Juan and Juanette. I'm sorry if I get informal, it's just the way I am. Please don't take it as any disrespect to the panel or my investigators. I'm just that type of guy. So Juan and Juanette contacted me and said at one point in the evening, again, I have to look at my notes, but I'm guessing around 8 or 9 o'clock at night, they called me up and said that they were beginning to receive word about threats of their arrest should they continue to attempt to make service of this document. On a personal note, I care very much for my employees and my investigators. They are my subordinates. I see as a major part of my job is taking care of them. And hearing that they were being threatened with arrest for attempting to serve summons of the Superior Court caused me great concern. At that point in the evening, I reached out to a member of the local Federal Bureau of the Federal Bureau of Investigation who was assigned locally here in the CNMI, an individual I've worked with personally and professionally before, and I asked him if he would be able to assist us in effectuating service of this document. I did so because I know that CNMI statute and the rules of criminal procedure allow for the service of summons to be effectuated by any person over the age of 18 who is not a party to the suit or a party to the case. So what that means is anybody in the CNMI who's an adult and who is not a named party to the case can effectuate service of process. In my mind, that included a special agent of the FBI. OPA also, and I don't know if you know this or not, but OPA also has an existing relationship with the Federal Bureau of Investigations. We are members of an anti-corruption task force, and we routinely do work together. Now, I contacted the special agent from the FBI, and initially, what I envisioned happening is this individual would assist our investigators at OPA with serving the document to Mr. Buckingham prior to his departure from the CNMI. Because of the events that I'm sure you have become very familiar with, that ultimately became impossible. So the document was served by agents from the FBI. My understanding is that service was effectuated inside the Delta VIP Lounge at about 10 till 5 in the morning on, the 4th of August. So that's Saturday morning, very early. Quite frankly, it was served by the FBI because I had run out of options. My staff is limited in their number and their resources, and I was encountering a situation where not only was the subject of the summons actively evading service, it was becoming apparent that elements of certain governmental agencies were aiding him in avoiding service of that summons. So, sir, I ran out of options. I called for help and I received it. Had we not gotten that help, I'm convinced that Mr. Buckingham would have been able to leave the CNMI and the summons would not have been served.
Thank you. Would any of the members want to pose any questions now? Representative Torres.
Mr. Hasselback, in your opening statement, you mentioned that you did not effectuate the subpoena or penal summon. Is that correct?
Me personally, sir? No, I was not the one that effectuated service of the summons.
I have a document here that stating that you signed the information to the clerk for penal summon.
Yes, sir, I did. I signed the, and please excuse me if I'm explaining something you already know, but the procedure is when one files a criminal case, one files a document called an information. In this case, there has been an information and an amended information later, but we're talking about the initial information. I did sign that document, yes, and I presented that document to the clerk of courts, and the clerk of courts signed a document, signed the penal summons. So the two documents interact. The penal summons is the command to appear before the court. The information is the document that lists out the specific charges that justifies the penal summons. So that is correct, sir. I did sign the criminal information, but the penal summons, the command from the court, was signed by the clerk of courts.
Thank you.
Thank you. Just a request to the members. I understand that the information is attached to the subpoena duces tecum. However, it relates to another incident and another article. So I ask the members not to pose any questions at this time to Mr. Hasselback regarding what's contained in the information that he filed until such time that we take on the matter, I think, tomorrow. So Mr. Hasselback is going to be asked to appear again,
yes, sir.
Tomorrow to answer to those articles. So
now, just to be clear, Chair, I'm sorry to interrupt. The amended information does contain allegations concerning the subject matter before the panel today. That, of course, came up after these events transpired, and I filed the amended information.
correct. Vice Speaker?
Thank you, Mr. Chairman. Just so that I am very clear, what exactly did Buckingham do for you to serve him a summon?
Well, ma'am, I came to the Office of the Public Auditor in February of this year. I was assigned to be in charge of the investigations unit, which primary responsibility is to investigate allegations of fraud, waste, and abuse of governmental money and resources, and to investigate complaints concerning violations of the CNMI Government Employees Ethics Code. Pursuant to those duties, I not only began to initiate cases, I also inherited a set of cases that already existed. One of which was the investigation of former Attorney General Edward Buckingham for those issues that came up in the initial information, which the Chair has mentioned will be brought up later. But speaking generally, I reviewed the information that the Office of the Public Auditor had. At a certain point, Michael Pye, the public auditor, recused himself from these issues and asked me to act in his stead. And I essentially reviewed the information that we possessed. I determined that we had sufficient admissible evidence to support the criminal charges contained in the initial information. And when it became apparent that Mr. Buckingham was leaving the CNMI, presumably never to return, in fact, that's what he said in an interview with the press on Wednesday of that week. I think that was the 1st of August. When it became clear that he was leaving the CNMI, it became evident that unless he was served with some sort of summons concerning these charges that we were considering filing, that he would not be answerable to the courts of the CNMI for the foreseeable future. So in other words, I was in possession as a member of a team in the Public Auditor's Office. I was in possession of information that I believe supported criminal charges, and we have a statutory duty in that instance to investigate and, if warranted, file such charges, and that's what I did.
And what are those charges?
Those charges
Just list them very briefly.
I'll do what I can, ma'am. Those were contained in the initial information. My apologies to the panel. I wasn't able to present a copy of the amended information. That's filed with the Superior Court. But the initial information contained one count of prohibited use of public supplies, services, time, and personnel for campaign activities. One count of the use of the name of a government department or agency to campaign and/or express support for a candidate running for public office. One count of misconduct in public office. One count of failure to produce documents or information to the Office of the Public Auditor when properly requested. And one count of misconduct in public office. And I'm doing this from memory, please forgive me if I don't get the details right, but the amended information, to the best of my recollection, includes one count of obstruction of justice for the avoidance of the service of summons, and another count of misconduct in public office.
Thank you. Mr. Hasselback, there was a report that was hand-delivered to the governor's office and the office of the lieutenant governor, dated December 13, 2010. And Mr. Chairman, a copy of that report was submitted to the special committee as a result of our request for documents that were submitted to us. And in that report, you outline the different allegations or the recommendation report and recommendation made on the ethics investigation that was conducted on the Attorney General in Buckingham. And then that's the only report that I have in the package that was received from the Office of the Public Auditor. But I was wondering what happened to the copy of the letter of the governor to the Office of the Public Auditor relative to this, the report that was prepared by the public auditor. There was a response made by the Office of the Governor, on the report that was produced. Supposedly was confidential. Do you have a copy of that report?
No, ma'am, I don't have a copy presently with me.
Is there any reason?
No, wait, you mean a copy of the December 13th, 2010 letter from the Office of the Public Auditor to the Governor?
No. It's the report was dated December 13, 2010.
Yes, ma'am.
And then the governor submitted his response to that report, which was dated January 6, 2011. And I'm just kind of wondering, why wasn't that, or is there any reason why was the report not attached? I mean, the response of the governor not attached to that report that was issued by the Office of the Public Auditor?
You're asking why we did not submit a copy of that letter to the panel as well?
Yes.
Okay. Ma'am, frankly, I don't know if there was a response from the governor's office. I think that we should have included that in our response to you. I'll be happy to go back and review our files and make sure.
It's a 10-page report, 10-page response.
Okay.
And I think, Mr. Chairman, if I may, I can just give in a copy of that just to make it available to the other members, so that if a little later on in our deliberation we should ask questions, they should be able to refer to that report. And then, as a response, excuse me, I think I...
Vice, just to remind you...
Excuse me, can I just... yes, Mr. Chairman. I
don't think anybody has any objections to you making copies for the members.
No.
But as far as getting into a matter that is in Articles, I believe, 1, 2, 3, that would be tomorrow, and that's why I asked the members, if there's no objection, that we limit our discussion today on matters relating to Articles 4, 6, and 11.
I have no problem. I just thought that I should bring this thing up because we are still discussing we are discussing on Mr. Buckingham, the former AG. I think I just handed by mistake a copy of a letter. And then in response, if I may continue, Mr. Chairman?
Let me clarify.
If I may continue, it's not going to be anything long.
Let me clarify,
Vice.
Vice. To that. Vice, let me clarify. You may continue. Again, when you say related to Buckingham, there are several different incidents relating to Buckingham. There's Buckingham leaving to the airport, and that's a separate article. There's Buckingham associated with the Hatch Act, which is included for tomorrow's discussion. And so even though both relate to Buckingham, you may, Vice Speaker, continue with matters relating to Articles 4, 6, and 11.
That's fine. Thank you, Mr. Chairman. And I just want to make sure that the members have copies of this correspondence before we continue our meeting tomorrow. Then in response to the governor's letter, the OPA's, the response of the governor to the OPA's report, the OPA wrote back a letter, wrote a letter dated January 25th, 2011 to the public auditor. I'm sorry, the public auditor wrote the January 25th, 2011 letter to the governor, which essentially says that the matter at hand on Attorney General's involvement with the party that was held at his place is closed. And I would like that we take that matter up further, Mr. Chairman, when we go into our meeting with Mr. Hasselback tomorrow.
Thank you.
After. And I would like this letter to be copied for the members.
Thank you, Vice. No objection. Now, perhaps we can resume. Mr. Hasselback has given us his statements relating
I have a couple other questions.
Relating to Articles 4, 6, and 11, I recognize the Vice Speaker.
Yes, and it has to do with the power to prosecute. And I was going to direct a question to our legal counsels to answer as to, under the Constitution of the CNMI, who is empowered to prosecute. I do know that Mr. Hasselback referenced the statutory authority that gave him that power to initiate the action against Mr. Buckingham, but can you tell us, under the CNMI Constitution, and maybe you can read that provision, who is empowered to prosecute any violations of our CNMI laws?
Article 3, Section 11, relating to the Attorney General, provides that the Attorney General shall be responsible for and providing legal services in that, and representing the Commonwealth in all legal matters and prosecuting violations of Commonwealth law. The next section relates to the public auditor. It generally states the responsibilities of the public auditor, and further provides that the public auditor shall provide all other duties provided by law. So if a law were to be enacted requiring the public auditor to prosecute in certain instances, then the public auditor would also be authorized. The question is, does the Constitution grant exclusive authority to prosecute? No, it doesn't say that. It just says the Attorney General shall be responsible. And that may be the argument that's going to be addressed by the court. I don't know. I haven't seen it.
Ma'am, to my knowledge, there has never been, this question has never seen judicial scrutiny. The question of whether or not the Constitution grants exclusive authority to prosecute violations of Commonwealth law to the Office of the Attorney General, or does the Constitution grant the general ability to prosecute violations of Commonwealth law to the Attorney General's office, leaving it open for statute to allow other agencies to? That is a question that the CNMI courts have not addressed previously. I'm of the opinion that the latter is true. I'm sure there are people out there that will disagree with me. But the final arbiter of that question will be the courts of the CNMI.
Well, under the present language of the CNMI Constitution, Mr. Legal Counsel, are we saying that we pass a law that is not clear, that is debatable, that is confusing? The language of the Constitution is very clear.
Correct, and so was the
So
law.
are we putting in our own interpretations? And are we also saying whether that statute is unconstitutional?
No, we're not saying a statute is unconstitutional. The Constitution specifically authorizes the legislature to provide other duties for the public auditor. And in this case, the law that was enacted is quite clear, and it's extremely limited. It's only in circumstances where the governor or the attorney general has found to have violated Commonwealth law, and no action has been taken by our chief law enforcement agencies. That's the only
Mr. Legal
single
Counsel?
instance.
If the Constitution is leaving the legislature, giving some power to the legislature to make other determinations, then wouldn't it say in the Constitution as provided by law? There is nothing as provided by law in the language of the Constitution that I'm reading.
It says the governor shall appoint a public auditor. Legislature, judicial branches are subject to, let's see, the Commonwealth and the agencies. And the final statement of that is, if you read it, the governor shall appoint a public auditor who shall, with the advice and consent of each house of the legislature, the public auditor shall audit receipts and disbursements of public funds. And the last clause is, and shall perform other duties provided by law. So it's very clear in the public auditor's authorization section that the public auditor is required to perform other duties that may be designated by the legislature.
Thank you, Vice. Any other members? Representative Guerrero?
Yeah. Hi, Mr. Hasselback. I don't have any questions, right? I just have a brief comment. You've said I don't know twice already. I don't think you came in well prepared for this hearing or this questioning. I would just ask you to give us your due respect, and tomorrow please come in well prepared. The missing documents that we have to dig up ourselves, it shouldn't be missing. You should also have put it in. So that's all I'm going to ask. Please show some respect to this committee.
Sir, I intended no disrespect because of the missing documents. I will search those out and find them for the panel. But I would like to clarify, sir, that when asked by a member of the panel to explain the legal reasoning and the supportability of opposing counsel's argument, which I don't agree with, when asked why opposing counsel has done something they've done, the only answer that I can give you is I don't know. I can't reach into the mind of another person to determine why they did something, why they proposed a certain argument. I simply don't know. I do recognize that this individual has proposed this argument. Mr. Buckingham's attorney has argued that I lack prosecutorial authority in this action. Mr. Buckingham's attorney has proffered lots of things. When asked why he did that, I cannot, other than to make something up, give you an answer other than I don't know.
Fair enough. Rep, do you have anything further? Thank you. Any other members want to pose a question to Mr. Hasselback? Mr. Hasselback, well, before anybody else raises their hand. In addition to those documents that you are going to look for, also please provide us with a copy of the amended information. I think there are 2 more counts, correct?
Yes, sir, there are.
By tomorrow.
Yes, sir.
And those 2 counts are relevant to Articles 4, 6, and 11 because you are basically charging him with obstruction, I think was one of them.
I'll be happy to explain to the panel precisely what those 2 counts are.
Mm-hmm.
The first count is a count of obstruction of justice. Obstruction of justice in the CNMI can come in many different flavors. One form of obstruction of justice is someone who attempts to avoid or obstruct service of judicial summons. That was the first additional count. I allege that Mr. Buckingham undertook a pattern of behavior intended to avoid being served with a judicial document. The second charge is an additional charge of misconduct in public office. Misconduct in public office can be one of 2 things. Either a public official either a public official does something illegal under color of their office, or a public official knowingly refuses to fulfill their duties as a public official. In this instance, I alleged that Mr. Buckingham, in his position as Attorney General, used his position and influence as Attorney General to commit the illegal act of attempting to avoid service of process. And those are the general factual allegations that are contained in those 2 counts. The other counts remain unchanged. They weren't touched. I just signed off on, I cut and pasted those into the document, added 2 new counts, and that's the amended information.
Thank you, Mr. Hasselback. And by submitting those amended information, you feel or you are certain that those law enforcement individuals that prevented the penal summons from being served, that they were under orders from Mr. Buckingham?
Let me be specific, sir. The first count, the obstruction of justice count, I believe that I have sufficient admissible evidence to prove all of the elements of that charge. Generally speaking, that Mr. Buckingham knowingly and willfully attempted to avoid service of summons. The second one is, like I said, it's a misconduct in public office charge, and the elements necessary to prove that, generally speaking, would be that Mr. Buckingham was a public official and under color of his office did something illegal. Neither of those 2 charges require the involvement of other persons. I have not filed any criminal charges that require proof of action by anybody other than Mr. Buckingham at this time.
Thank you. Mr. Hasselback, you know what the articles of impeachment, the 3 that I have cited several times.
I've reviewed them generally, yes, sir.
Right. Do you have any information which would lead you to believe that those articles are valid allegations?
I was placed in a very unusual and difficult situation. What I thought would be a fairly routine service of a judicial document. And again, please keep in mind that law enforcement officers in the Commonwealth are obligated by CNMI statute. It's in our criminal It's in the criminal code, criminal procedure section, 6 CMC 6101. I would encourage the members of the panel, if you have not already reviewed that statute, to please take a read. I'm sorry.
Could you please recite that?
6 CMC 6101. That statute obligates, in no uncertain terms, every law enforcement officer in the Commonwealth of the Northern Mariana Islands to serve judicial summons when they become aware of them. The reason that this situation, Mr. Chairman, was so unusual is because we began to encounter a situation where we initially received cooperation from law enforcement officers in attempting to serve Mr. Buckingham with the summons. Over the course of the evening, that cooperation dissipated. Now, the whys and the wherefores that cooperation dissipated are still a matter of active investigation. What I do know is, I, as a supervisor, was sending people out into the field to do their jobs, and those people were being threatened with arrest. That is a very, very unusual circumstance. I've never encountered it. Now, my experience is not limitless. I don't know everything. In fact, I know very little. But I have had some experience with the service of judicial documents, and this is the first time that I've seen a situation like this develop.
Thank you. And I think there's a good analogy that you have just provided. Why you would ask the FBI to serve the summons, and it's because our local law enforcement were prevented from doing it. And it kind of, a similar analogy can be made. Why should the OPA be able to prosecute when the Attorney General should be the one prosecuting? However, what happens if it is the Attorney General that needs to be prosecuted? Who prosecutes him? And I think that kind of goes to show why the Constitution allows for statutes to clarify situations like that. Do you agree?
Sir, I think that the statute under which I'm operating is constitutional. Otherwise, I wouldn't operate under it. Again, the ultimate determination of the constitutionality of any statute is for the courts of the CNMI to decide. Perhaps I've talked in very general terms about a lot of things. Perhaps it would be good for the panel to understand there are two statutes that I've mentioned about service of process in my discussion with you here today. One statute says, well, statutes and court rules say, generally speaking, anybody in the CNMI can serve a judicial summons if they're over 18 and they're not a party to the case. On the other hand, 6 CMC 6101 mandates that a certain segment of our society has to serve judicial summons if they're aware of them. That segment of our society are the law enforcement officers. Our statutes say that a law enforcement officer has to serve a summons if he or she becomes aware of it. Now, there's been a lot of question about the validity of the summons. However, those questions are not left up to the men and women of law enforcement. The validity of a summons, the constitutionality of the statute upon which the summons is based, those things are left to a court to determine. But whether or not to serve a summons signed by the clerk of courts, that our law enforcement community, with all due respect to them, and I have a great deal of it, with all due respect to the men and women we have in uniform in the CNMI, they don't have a choice. When they are presented with a summons from the Superior Court, they have to serve it. The target of the summons, the criminal suspect, has constitutional protections. They have the right to counsel. They have the right to remain silent. They have the presumption of innocence. All of those things seek to protect them, but that summons must be, once issued and legitimately signed, must be issued by law enforcement. They don't have an option. And that was what made this situation so incredibly unusual, and that's what caused me to seek help from our federal counterparts.
Thank you. One more clarification, since you seem to be very aware of the statutes surrounding the authority to issue a summons. And I think you've already answered this, but let me just state it anyway. Can a law enforcement personnel be arrested for issuing a summons?
Can let me make sure I understand your question. Let's take generic Officer Smith. And my apologies if there is an Officer Smith out there. Just hypothetical Officer Smith. Officer Smith has presented a penal summons that, much like the one here, it is signed by the clerk of courts. There is no facial defect in it. It is, looking at it, it is a legitimate penal summons from the court. Officer Smith goes to effectuate service of that summons, walks up to an individual on the beach and says, "Mr. Jones," again my apologies if anybody's last name is Jones, "Mr. Jones, I have a piece of paper for you." Mr. Jones accepts the piece of paper. Are you asking me if Officer Smith can be criminally charged for some reason or punished for that?
Well, I guess in this case there's more relevance because apparently one of your investigators was instructed that if he or she had served it, they would be arrested. Now my question is, legally, does anyone have the authority to arrest your staff for issuing that summons?
Absent some other grounds to arrest someone, to my knowledge, there is no supportable legal basis to arrest an individual simply for serving process of a document. That is not only a legal act, but it is, in some instances, an obligatory act. My investigators are law enforcement personnel. They are obliged by 6 CMC 6101 to seek to serve any judicial summons they're presented with. So, to answer your question again, I cannot think of any supportable legal justification, absent something else, that would justify the arrest of a person simply for attempting to serve a judicial summons in the manner in which you described.
Thank you, Mr. Hasselback. I'll now yield to other members. I believe Representative Sablan has been raising his hand.
Thank you, Chairman. Mr. Hasselback, prior to taking your current position at OPA, I understand you were an assistant AG?
Immediately prior to taking my position with the Office of the Public Auditor, I worked for the public school system. I was one of the legal counsels for the State Board of Education. Prior to that, I worked at the criminal division of the AG's office.
In what capacity in the criminal division?
I initially started out as a criminal prosecutor and assistant attorney general. My initial duty assignment was prosecuting crimes of domestic violence. Now that's not to say that's all that I did. Everybody down at the criminal division of the AG's office has a hand in everything. Like everything else here, you become a jack of all trades. So I did some traffic cases, some drug cases, but primarily I did domestic violence cases. After that, I was, for a period of about 90 days, I was the acting chief prosecutor, and then after I was the acting chief prosecutor, from that point until the time that I left the AG's office, I went back to being the domestic violence prosecutor again.
Okay, so as your capacity as prosecutor, time to time, I'm assuming that you've had the opportunity to have worked with law enforcement personnel, in particular DPS officers?
Very closely, and in general, it was an incredibly positive experience.
Okay, and my question then is this: in your experience working with officers, do officers generally, frontline officers generally, go out on their own and make certain decisions without sanction of higher-ups? I'm talking about chain of command and stuff like that. Day-to-day, of course, day-to-day. I'm not talking about day-to-day, because what transpired on this particular date is not every day. And I'm just trying to get at the idea that in law enforcement we have a chain of command, and generally officers in the field are accountable and understand their day-to-day roles and their decision and discretions in the field. Can you share with us your impression of how a law enforcement organization like DPS works in regards to what kind of instructions come from where and from who?
Let me preface my response by saying I've never been a police officer. I have, as you've indicated, I've worked closely with them. I have an incredible amount of respect for the job that they're called upon to do. I can say that I've encountered, in my experience, in my encounters with law enforcement, my understanding is that the majority of an officer's day-to-day experiences are covered by some standing policy, some standard operating procedure. It's normal business as usual. So most of the time, an officer on the street, he or she will be able to make quite a few decisions on their own, because they go to an academy, they're very well trained, they're experienced, they tend to know what to do. My experience has been when they get outside of that norm and they get in a situation that maybe isn't covered by one of their standard operating procedures or isn't covered by something that they know about, when they get out of that, they seek guidance, generally speaking, from two sources. First of all, they always pick up the phone and call the lawyer, which, I don't know if I recommend calling lawyers all the time, but they always pick up the phone and they call somebody from the AG's office to seek legal advice. As far as procedural advice, how and what to do, that call, in my experience, what I was told that the officers did was they would usually contact their shift supervisor or their more experienced partner, someone further up the chain of command. I don't have any specific information for you here today, again, because these issues are still under investigation. I don't have any specific information for you here today as to what was said to whom and when. What I can tell you is, from the perspective of the person who was supervising and observing the actions of the investigators for OPA, in that capacity, I saw, in the beginning, cooperation from the Department of Public Safety, uniformed officers. In the beginning, I saw cooperation from the Commonwealth Ports Authority, uniformed officers. At some point in time, that cooperation disappeared. I do not know specifically what caused it to disappear. Again, that is a matter currently being investigated. But whereas initially officers from both the Commonwealth Ports Authority and the Department of Public Safety were ready, willing, and able to help us effectuate service of this document, something caused that to change. Now, you heard testimony from Juan and Juanette. I didn't hear it. I'm sure they told you some of the initial reports that we've been hearing, what caused those things to change. We are working to confirm those reports.
Thank you, Mr. Hasselback. Chair, are you?
Thank you, Representative Sablan. Are there any further questions to Mr. Hasselback? I think the time is quickly approaching dinner time, and maybe we should wrap it up. So if there are no further questions, at least relevant to Articles 4, 6, and 11, we will continue with our interviews and receiving of testimonies tomorrow. Mr. Hasselback, we want to thank you for your testimony today. Tomorrow, starting at 1 p.m., we will continue with the other articles in House Resolution 17-111. I believe we would be touching on Articles 1, 2, 3, 5, and 7. And as Representative Guerrero advised, to please look over the subpoena ducis tecum that you were
Yes, sir.
asked to provide, and whatever was not provided, please do so tomorrow. Be prepared to answer to those documents. And in addition to that, I think we made two requests. One is that you provide the additional information, the two additional informations to this body tomorrow, and also the request by the Vice Speaker that any correspondence from the Governor to OPA and OPA to the Governor, that you please bring those along as well.
Yes, sir.
Thank you very much for your cooperation. We will see you tomorrow.
That's tomorrow at 1 p.m., sir.
At 1 p.m.
Thank you very much.
Thank you.